All right, this is Rudy. It's December the 1st, the year 2016, and I've got a big manila envelope that came in the P.O. Box today, care of Robert David Neal, 15151180, Federal Corrections Institute, P.O. Box 33, Terre Haute, Indiana, 47808. It's dated November the 21st, the year 2016. This envelope contains 15 pages. Please advise if all are not enclosed when received. And there is 15 pages in the envelope, so I'm not going to read all 15 pages. I don't know this guy, to be honest with you. We did talk to him and publish that call on YouTube. So this is mainly just recording for history and anybody that's interested later on. He did say he spent some time in the CMU, and we'll just see what he has to say. Like I said, I don't know Robert David Neal all that well, nor I think his case had something to do with they charged him with insurance fraud and all kinds of weird stuff. All right. Monday, November the 21st, 2016. Dear Rudy and Aaron, thank you for taking my telephone call on Friday, November the 18th. In response to your question, you will find enclosed a biographical sketch which provides a historical abbreviated history of my career and situation regarding my illegal incarceration. I had previously mailed to you two very important sets of the 116 sets of Rule 36 judicial admissions confessions, forthcoming from two of these FBOP employees, which are now fully incorporated into the final adjudication of our case. For good measure, I am enclosing two more sets of these confessions for your review. One of these enclosed is forthcoming from Kathleen M. Kinney, the FBOP's Assistant Director, and is its General Counsel, Chief Attorney. And the second is once again put forward from Charles E. Samuels, Jr., its former Director and Chief Executive Director. These extensive confessions, 3,000 plus in total, as I told you earlier, are vital to our claim for justice as they reflect the extensive criminal activity of these despotic FBOP employees who so brazenly admit to their criminal activities as if they will never be held accountable, which to a large extent is sadly true. I am enclosing a sworn affidavit outline of the 126-page settlement between myself and the FBOP and the federal government, which was completed on December the 9th, 2009, that these self-confessed FBO criminals have refused time and again to respect. The certificate of innocence adopted in this settlement, and so authenticated by all of the 76 FBOP employees who gave up these 3,000 plus judicial confessions, which is actually much stronger than a presidential pardon. A pardon assumes that a crime may or has been committed, but the receiving party will not be held to account for it. A certificate of innocence stipulates that no such crime ever occurred. You asked about this Communications Management Unit, or Guantanamo North, as the national press so accurately describes it. Let me direct you to Rule 36, confessions from Samuels I had previously sent to you, and look in particular at numbers 34 through 126. You will note in a particular confession number 117, wherein Samuels has confessed that this program is in fact a criminal racketeering influenced criminal organization, RICO, racketeering influenced criminal organization, engaged in the crimes of human trafficking, witnesses retaliation, civil rights violation, obstruction of justice, obstruction of mail delivery, wire fraud, mail fraud, torture, assault, perjury, and falsification of government records, among other ongoing crimes. As I told you in the previous letter, our entire situation has now evolved into the largest fully adjudicated false imprisonment damage award in American history, and is now due and payable from the U.S. Treasury as such. The only real issue for the pending arbitration proceeding will be allocation and assessment of these massive financial damages to this criminal RICO FBOP employees, which they themselves caused to occur. Understanding that the federal government and I are sitting on the same page against these criminals, with everything resolved, with the settlement reached so long ago, it will be incredibly interesting to watch these criminals scramble to protect their home equities, motor vehicles, deposit accounts, retirement accounts, and more in this binding and unappealable arbitration proceeding which has come about because of their own self-confessed crimes. As part of your efforts after you have put together your information for the internet streaming, I would truly appreciate it if you would also send a copy to the Prison Legal News at www.prisonlegalnews.org. This is great organization, and they would love to print up stories on these matters. Thank you again, and God bless you for your continuing efforts against these self-confessed criminals who are of the worst kind. I will call again in a few days when I am able. God bless and take care, David. That's interesting, prisonlegalnews.org. I'll check it out. And as far as his problems with Charles E. Samuel Jr., who was the former BOP director, I completely agree that he's an absolute criminal, appointed by Obama, and I have no problem believing Charles E. Samuels Jr. is an absolute crook. There's no doubt in my mind that that's the case. But in any event, let's read the back of the page. It says, P.S. These two sets of enclosed Rule 36 judicial admissions confessions were also properly authenticated and validated by Charles Samuels himself in the previous admissions I sent to you in my previous letter. See the previous admissions number 134 through 136. All of these were collectively and individually authenticated and validated by FBOP employee Leanne LaRiva and a former warden at this facility, and now filed into our closed case court records as claim for mandatory judicial notice, Fed R. EVID number 3. By providing multiple layers of these document authentications, no one can ever claim there is an underhanded or fraudulent process at work, as this is what these people love to do. Everything is above board and fully disclosed, unlike what these secretive criminals do all of the time. We gave them so many chances, 116 in all. I wonder if 117 was the magic number to make these criminals want to pay attention to the mandates of the federal court rules. Oh well, praise God for their stubborn attitude of ignoring the truth and the facts of the matter, and thus allowing us so many confessions of extensive criminal behavior, now all fully adjudicated as such in an unappealable and binding federal court proceeding. Let me say this as I'm reading this page. Russell Landers, who I believe is in the same prison as Robert David Neal, he was working with some people on the outside, and they disappeared. And then not only that, but Russell Landers got stuck with like 30 or 35 more years in prison simply because they said that he was trying to extort money from a judge, or they held his bank. I don't know what they did. Let me just say for the record that I don't know Robert David Neal. I've never met him. I've talked to him on the phone, and I'm not participating with him in any of this activity. I'm simply reading his letter. But I'm in no way I don't even know what all this legal stuff means. And it's not to say that I wouldn't do something if I thought it was the right thing to do, but I don't even know anything about all this. I mean, I don't know Robert David Neal. He just started writing me letters. Whether he's innocent or not, I have no idea. And, you know, it's obvious that the government wants to set me up. Now, is it possible they're using Robert David Neal to set me up? I guess that's always a possibility. I find it very strange that the letters that come from Robert David Neal are not even, he puts stamps on his manila envelopes, right? And usually when a packet goes through the United States mail, it's stamped with a wavy stamps indicating that the stamps, but none of his letters are ever stamped. I mean, it's like I could reuse the stamps if I want to. I don't mean they don't have stamps on it. I mean that, you know what I mean? When you put a stamp in an envelope and you send it through the mail, they take a wavy dark lines and they stamp the stamp so that it indicates that it's a used and you can no longer reuse the stamp. But his letters don't ever have that, which makes me think that it was hand delivered to my P.O. box. And maybe they're trying to avoid performing wire fraud themselves. And it's very possible this could be a setup for me, right? Because I don't know anything about Robert David Neal. And I'm making it clear that I read his letter into YouTube. But I'm not participating in any of his lawsuits, nor do I want any money from his lawsuits. I'm just simply reading what the guy wrote me, and you guys make the decision if it's accurate. Now, is it possible he's a good guy trying to fight for his freedom and he's, got caught up in a bad situation? I don't know. A lot of this stuff is over my head, man. All this. Anyway, here he sends me a letter called Biographical Data, Robert David Neal. I graduated from the University of Texas at Arlington with honors in 3 years, with a BBA in economics in 1971 and later with an MBA in 1973 in finance. I had attended the university on a track and basketball scholarship and had been a 2-year cheerleader and a member of the Delta Tau Delta fraternity. Following graduation in 1971, I commenced my working career in the commercial banking industry, initially with the First National Bank in Dallas and later with Wells Fargo and Company. This commercial banking career continued until 1985. Upon leaving Wells Fargo, I was the youngest senior vice president in the company, overseeing the entire commercial loan portfolio of the company over 5 states from an office in Dallas. This loan portfolio was a multi-billion-dollar responsibility. From 1985 until 2002, I operated as a self-employed entrepreneur, investor, and venture capitalist, acquiring financial interest in a variety of commercial businesses involved in such diverse industries as technical and scientific books and journals, distribution, gasoline tracking and distribution, metal plating and finishing, precision sheet metal fabrication, screw machine parts manufacturing, and office supplies and automotive parts distribution and retailing. Additionally, I was the owner of shopping centers and apartment complexes. Among these businesses acquired and built was the largest automotive parts distributor in North Texas, Northeast, and South Texas, which eventually merged with Hilo Automotive, a public company, which later merged with another to become O'Reilly's, the national chain. For 2 years, I was the largest shareholder of Hilo, a publicly traded company on the NASDAQ. Retired in 1992, my career was put on hold to play golf until 1996 when I entered the health insurance business with the founding of the National Association of Working Americans, DBA American Benefit Plans. Along the way, between 1997 and 2002, I also involved myself in municipal politics with the city of Trophy Club, Texas, serving as a city councilman, serving on its Parks and Recreation Committee, chairing its Ways and Means Finance Committee, serving as the president of its Economic Development Corporation and its delegate to the North Texas Council of Governments and the Texas Municipal League. National Association of Working Americans, DBA American Benefits Plans. Originally conceived in 1996, the National Association of Working Americans, DBA American Benefit Plans, NAWA-ABP, was chartered as a nonprofit corporation in the Texas state with the specific intent to provide limited beneficial medical plan options to blue-collar working Americans through their workplace. In 1998, NAWA-ABP contracted with United Employers Voluntary Beneficiary Association, UEV-EBA, a California-based organization chartered pursuant to Section 501c9 of the Internal Revenue Code, i.e. Title 26. The contract was specifically drawn to market and underwrite the benefits brought forward by the UEV-EBA. Over the course of 3 to 4 years, NAWA-ABP UEV-EBA grew to the largest organization of its kind ever in the United States, with over 700 plus employer members spanning some 40 states. These employer and other organization members included Yum Brands, the national franchisor of Pizza Hut, KFC, and Taco Bell; American Dairy Queen, a Warren Buffett Berkshire Hathaway company; Burger King, the Screen Actors Guild, the American Federation of Teachers, the Communication Workers of America, over 200 nursing homes and home health care agencies, plus some 70 multi-state employee leasing companies. NAWA-ABP UEV-EBA was illegally closed and liquidated in a 2002 receivership initiated by the Texas Department of Insurance. In the receivership liquidation, the reinsurance premiums that's paid to 2 large insurance carriers covering 100% of the members' benefit claims were confiscated, leaving the members devoid of a viable option to secure full payment of their outstanding claims. This action allowed the attorney receiver appointed by the Texas state to loot over 70% of the trust assets for his own personal enrichment, leaving the plan members holding the bag for massive unrecoverable losses. Although I was verbally abused and accused of many, many bad acts in the receiver's facade to cover up his own bad acts and justify his absconding with the UEV-EBA trust assets, I was never charged with any violation of the state and federal statutes involving my fiduciary duty, NAWA, ABP, UEV, EBA, and if I had done anything wrong, I most certainly would have been charged and convicted. Hilda L. Solis, President Obama's first Secretary of Labor, has put forward conclusive judicial admissions pursuant to Rule 36 of the Federal Rules of Civil Procedure, which have directly spoken to the integrity of my actions regarding NAWA, ABP, UEV, EBA, and the criminal acts of the receiver related thereto. Criminal conviction. In May of 2002, I was coerced into pleading guilty to a crime I knew I did not commit, false claims against the federal government. This involved my filing for a tax refund of $240,000 based upon my prior dealing in Mexico. This forced plea was made because I was so compromised by allegations from NAWA, ABP, UEB, EVA receiver, I could not take the witness stand in my own defense as I would be crucified by these unrelated and bogus claims. And 2 nights before the commencement of the trial, my long-term CPA tax accountant was mysteriously poisoned with life-threatening blood poisoning agent and was hospitalized in the near-death experience. This crime has never been solved. I wonder why. In an agreement which included some programming credits and home confinement mandates, I was to serve 10 months in a federal prison. I was actually released some 25 months later, being held over under intense pressure from the Texas State Receiver. 8 months after I was in prison, the civil section of the IRS concluded that my requested refund was actually some $420,000, an amount I was never paid because the statute of limitations had run out to get the funds I was now declared to be due. This is the only known case of a person being incarcerated with the government later acknowledging he was correct all along, but since he had pled guilty, too bad. After release from the federal prison, I was hounded unmercifully by the Texas State Receiver and the U.S. Probation Office. My supervised release was revoked after 8 months in the September of 2005, and I was placed back in a federal prison for another 23 months. When the sentencing guideline was only 3 to 9 months. In November of 2006, while still in federal prison, I was charged once again for a wire fraud case which simply did not happen. As denoted in the David Berkebile and attached Charles Samuel Rule 36 admissions, I was denied my right to face my accusers in a trial, and I was sentenced in absentia to another 27 years. 27 years in federal prison. This was successfully accomplished by the appointment of legal counsel without my prior consent, who then appeared in court and pled guilty for me, forging my name to various documents so filed into the court. I never saw the court again. The clerk of the court, witnessing firsthand the events confessed to by Berkebile and Samuels, and not willing to be complicit in my false imprisonment, purposely refused to place her court seal and countersignature on due mitimus, i.e. order of commitment as per 18 U.S.C. 3621C and 28 U.S.C.S. 1651 and 1691. In so doing, the court clerk denied the Federal Bureau of Prisons and its employees of the lawful authority to detain me for even 1 single minute. In December of 2009, recognizing my false imprisonment, a settlement was reached through my attorney with the FBOP and the U.S. Department of Justice regarding these matters. A certificate of innocence was issued in compliance with 28 U.S.C.S. 2513A1, 2, and B, in documenting the fact that I did not, by misconduct or neglect, bring about my own prosecution. Even so, I remain falsely imprisoned because these despotic FBOP employees would rather continue their ongoing crimes against humanity than simply comply with the rule of law. This settlement, as outlined in the attached sworn affidavit, has been ratified and authenticated by 76 employees of the FBOP who have claimed to have viewed a true copy thereof residing in the official files of the government as they relate to me personally. Even so, I remain falsely imprisoned in the terrorist-inspired torture chamber of the FBOP called its Communication Management Unit, or Guantanamo North. These FBOP employees have openly and defiantly confessed to violations of 14 various federal criminal statutes in a conspiracy designed to keep my voice from being heard, and my false imprisonment continued in a concerted trespass upon the full faith and credit of the United States itself, i.e. the acts of treason and sedition. These criminal acts of these FBOP employees have now evolved into the largest financial reparations award in American criminal justice history, with a day recompense at soon hand. With a day recompense at soon at hand. Praise God. All right, and then there's a sworn affidavit. Looks like there's 60. Comes now the undersigned affiant, being of majority age, competency to testify, good and moral character, with a yes and a yes and a no as a no, and in executing and presenting this properly prepared sworn affidavit under the pains and penalties of perjury, related 28 USCS 1746-1, would state the following, to wit: 1, and then he goes through 1 through 61 points. And then there's 2 sets of pages that are stapled together. And a lot of them has to do with Charles E. Samuels Jr., which I know is Obama's crook. But anyway, I don't know what to think of all that. You know, I'm not a legal guy, and as I read it, most of it is very confusing to me. And it appears that the guy thinks he's innocent of whatever they charged him for, and he expects to sue him for a ton of money. And he's going to try to hold some people accountable for doing bad things. But you guys probably know more about this stuff than I do, right? I'm just reading it. And later on, if he finds anybody that really understands in depth what he's trying to say, I'll point him to this video, right? But other than that, I don't know what else to do. Anyway, you guys have a great night. God bless.